Good afternoon to you all.
Your name is Nisha?
Ninisha.
Ninisha.
Sir,
Ninisha.
Yes.
You introduce yourself. For which interview you are here, by your academic credentials?
Sir, may I introduce myself? Sir, my
Yes.
name is Ninisha.
Briefly. After LLB, since you are meant for this artist.
Sir, I graduated from Rajiv Gandhi National University of Law, Patiala in 2023, and since 1 year I have been preparing for Rajasthan Judiciary Services, and this is my first attempt.
Okay. So, yes. After 4 years of history, then you have chosen for the RJS,
Yes, sir.
right? And this is your first time.
Yes, sir.
After getting success in your examination, what do you feel? What do you feel?
Sir, I will feel extremely good, but at the same time responsible also, because then I would have many responsibilities with respect to the society, and even after selection, I will increase my knowledge. I will read more law and information about societal issues.
Then why you opted for the judiciary? Why you opted for the judiciary?
Sir, fairness. So fairness and justice are one of the most important values in our society. And as a judge, I would be able to contribute to more and more welfare of the people and various sections of the society who are vulnerable, irrespective of their status or background, sir.
You can.
Yes,
Can.
sir.
You will do.
Yes, sir. Sir, progressive judgment, which is solely based on the welfare of the people with selfless feelings, can be advantageous for the society, sir.
हाँ, तो आपने पंजाब के बजाय राजस्थान क्यों चूज किया? प्रेफर किसको कर रहे हैं? पंजाब या राजस्थान में से किसको प्रेफर कर रहे हैं? एज ए
Sir, for
जुडिशियल ऑफिसर
judicial,
और जुडिशियल सर्विस.
sir, Rajasthan. Sir, because I was born and brought up in Rajasthan, and I have my cultural roots in Rajasthan, and I want to serve some my state.
आपके हिसाब से एज ए जज के रूप में क्या क्वालिटीज होनी जरूरी है?
Sir, one of the most important qualities is that a judge should be able to impart justice and give judgments impartially and without any external influence and biasness. Sir, moreover, a judge should have good listening skills, because if he has good listening skills, then only then he would be able to give a good judgment.
One thing I am asking you, suppose there are a number of for career factors, you can go in judiciary, you can also choose law profession. Why don't you choose this law? Why you're not choosing the law profession?
Any other profession apart from
Law profession.
Meaning
Apart
that the
from judiciary.
advocates, law officers, he's asking that. Why you opted for the judiciary
Only you are saying about judiciary. Why don't you choose in other professions? Advocate, the corporate law, and other. There are a number of branches in law also.
Sir, as a judge, I would be able to contribute to the welfare of the people at the grassroots level by my judgments.
You know, there are a number of advocates. I think you have not heard the name, but they have rejected the judiciary. Even they have been selected for High Court judge directly, but they did not choose. They chosen of the profession. Therefore, I am asking you how you are only for judicial service. In case, suppose you will not be selected, then you will go in the corporate sector, or you will choose this legal profession or other branch.
Sir, I will give my second attempt. Sir, I will give my second attempt.
All right, that you can second attempt, third attempt. I am asking this thing whether what is the second option
Sir, second option.
apart from judiciary?
Sir, I have been so passionate about judiciary since my first year that I had never thought about giving. Sir, since first year I had always
Well, I will give an example. There are a number of senior advocates, they have rejected this offering of High Court judge and Supreme Court, and they remain as an advocate. Then, because I know this thing that this profession is difficult for female. If you can go in the judiciary, that is a safer side. You can go in the lectureship, education side. But I am asking you only judiciary. Apart from that, what is your second option?
Sir, in case second option, sir, matlab, I would like to reiterate that I haven't ever thought about any second option.
We all, I wish that you select in judiciary. I wish you go up to the High Court, Supreme Court judge. But I am asking only this thing. Suppose, what is your second option, third option? Because in a life, you see, you can have a number of circumstances that we have to seek the second choice also.
Sir, in that case,
Okay.
sir, in that case, I will not, sir, stop for judiciary. Sir, in that case, I would prefer working under advocate, but at the same time, I will not leave judiciary. Sir, side by side, I will definitely study for it. But, sir, I just want to enter into judiciary only,
I
sir.
wish you all the best. Thank you very much.
Thank you, sir.
So you were brought up in Rajasthan.
Yes, sir.
Why you have joined this Patiala National Law School, Patiala College?
Sir, I gave examination for CLAT and in preference
You were
order I
selected
got,
there.
yes, sir.
You were selected according to your merit.
Yes, sir.
I see. What your father is doing?
Yes, sir.
Your father, what your father
Sir,
is doing?
he is a government contractor.
Contractor. And how many brothers and sister you are?
Sir, I have one sibling, a younger brother.
Younger brother. So he is studying in which class?
Sir, he is in college. He is pursuing MBA in Delhi.
So you are from the initially you are interested in joining judiciary.
Yes, sir.
Okay. So can we ask some questions?
What is ADR?
Sir, it is an alternative dispute resolution, which is an out-of-court dispute resolution system that is arbitration, conciliation, mediation. And sir, it reduces the burden on the court because there are lakhs of cases which are pending in India, and we need to resolve the cases through ADR process. So that it would be more easier to resolve the disputes within a time-bound manner. It will reduce burden on courts, and it is much more feasible for the parties.
What do you think? Is it any significance of the ADR? Present time, is it any significance of ADR or not?
So definitely there is significance. That is why we have Arbitration and Conciliation Act for the same, and so that is why in CPC in section 89 we section 89 read with order to have provisions for ADR. It holds an extreme significance, and sir, even a civil judge has to refer the ADR process to parties so that they can opt out of court settlement. And if it doesn't work, then sir, judicial process will be followed.
What is PIL?
Sir, it is public interest litigation. Sir, a person who is concerned about the welfare of the society and who is public spirited, he may file a petition under Article 32 or 226 of the Constitution of India in High Court or Supreme Court to represent the vulnerable sections of the society who are not able to file petition due to economic or financial crisis or some social crisis.
What is res judicata?
Sir, res judicata is under section 11 of CPC. Sir, it is a principle which is based on it is a principle which is based on the notion that there must be an end to litigation, and say there are certain essentials to this. So first is the parties must be the same in both the courts, and a matter which is directly and substantially an issue in the present court, it must be indirectly and substantially an issue in former suit also, sir. Also, the subject matter of the suit must be the same, and it must have been heard, heard, heard and finally decided. And so, lastly, the title must be the same.
So then you have gone through the presently enacted the criminal justice laws.
Sir, the new 3 criminal law.
Yeah.
Yes, sir.
Yes. What are the changes? Most of the 2 or 3 changes which are being initiated in this Bharatiya Nyaya Sanhita.
Sir, specifically in Bharatiya Nyaya Sanhita. Sir, in Bharatiya Nyaya Sanhita, sir, there are two So there are two major changes. First is a community service has been introduced. So, sir, the court may send a person for community service in case there are small offences such as defamation or theft. And secondly, sir, now the intercourse which has been done in by deceitful means have also been penalized.
Which
By
section? In which section?
which section?
Which speaks about this, the inducing the women for having deceitful intercourse. You want to have
Uh,
new.
Clause.
Huh.
Sir, it is under clause 69 of Bharatiya Nyaya Sanhita.
Yeah. Then, have you gone through the constitutional provisions also?
Sir, of
Constitution
Constitution of
article.
India.
Yeah,
Yes, sir.
you have gone through. Which constitutional article is the most important as far as citizens of India?
Sir, Article
Or
20.
and in your view,
Sir, pardon, can you please repeat the question?
in your opinion, which article of the Constitution of India is most important?
Sir, Article 21 is the most important article of India, which is based on life, right to life and personal liberty. And sir, it is the root of all the rights in India, whether it be right to privacy, identity of an individual. Sir, even Article 14 and 19 are also interconnected with Article 21.
What about 32?
So 32 is based on constitutional remedies, which gives the Supreme Court the power to issue writs, the five types of writs to protect the fundamental rights of the individuals under Part 3 of the Constitution, sir.
And what about complete justice? What about complete justice? What do you know under? What do you understand by the complete justice which has been merited in the Constitution itself?
So complete justice is not specifically mentioned in the Constitution, but in philosophy.
Have you gone through Article 142?
Yes, sir. Yes, sir. Article 142. Sir, in that case, the Supreme Court can give whenever a case is pending, sir, in order to the complete justice to the parties, the Supreme Court can make any order or decree which do the complete sir justice.
And what type of the cases? And what type of cases?
Some
What do you understand by the term complete justice? What is the need of coining this particular word?
sir, in case the lower courts are not able, sir, in case there is a lower courts are not able to resolve a particular issue or there is some
No, ultimately it is Article 142. So lower court has no connection as far as the Article 142 is concerned. It is up to the Supreme Court. It is for the Supreme Court.
uh, sir, complete justice in sense there is an is a matter which needs to be resolved by the highest court of India. Sir, for example,
In what circumstances? In what circumstances?
Sir, for example, in case a principle is not well settled in law, a principle is not well settled in law, there are no established precedents in law which are present in the recent cases. So, sir, in order to facilitate the judgments, in order to facilitate the justice, the Supreme Court may lay down new precedent, but it may lay down new principle of law.
Can you cite any one of the case, latest case in September itself?
Sir, as per Article 142 of
Yeah.
Sir,
Yes.
sir, a recent case which I referred was Kuldeep Kumar versus Union Territory of Chandigarh. Sir, in that case, the there was an election. Sir, I am not aware of the full facts, but the Supreme Court exercised the powers under Article 142 of the Constitution in an election matter, sir, in which an individual was not able to get elected due to some corruption or due to some um, mishandling of the votes in the booth. So, sir, the Supreme Court allowed that person to get selected to that position with respect to election, sir.
Why? What was the principle which was emerged? Have you gone through this Susuria's case and Kejriwal's case for granting the bail by the apex court?
Yes, sir. Sir, the Kejriwal.
What principle they evolved for granting the bail? Whether they have invoked the Article 142 or not?
Sir, as up to my knowledge, they quoted Article 21 of the Constitution of India and held that and Sir Arvind Kejriwal was custody for a long period of time, and so the Supreme Court granted him bail.
So yes. Why? By invoking Article 14, if it is 21, it is a must. Something. But the main principle which was emerged in this Kejriwal and Susuria's case was by invoking the Article 41, 42, 142 of the article, that they have done the complete justice, that longer the trial, we can't kept the accused in the jail.
Yes, sir.
Now I'm asking you, how many writs High Court or Supreme Court can issue?
So there are 5 writs. So there are habeas corpus, certiorari, quo warranto, prohibition, and
Of mandamus.
mandamus.
Suppose there is an order of the High Court direction to this state government or any of the department that you have to do it within a particular period, and the department did not obey the orders of the High Court, what the litigant would file before the High Court?
To order the state government to ensure duty.
To comply the order of the High Court,
Yes.
the litigant will come in the High Court in which writ?
Under which writ, sir? Some mandamus.
Yes.
Okay.
Now, you heard the Advocate General is the head, most senior advocate of the High Court, appointed by the, under which article? Advocate General. He is appointed by the government of Rajasthan, by the state of, any of the state of the Advocate General, under which article?
Of Constitution of India.
Of the Constitution. It is a constitutional post.
Yes, sir. Sir, Article 76.
Article 165.
Okay, sir, I was.
Article 165, the Advocate General is appointed by the state and Attorney General for the Union of India.
Yes, sir.
Under which article?
Advocate.
Attorney General.
Sir, I was confused between Attorney General and
Attorney General. Attorney General is one for the whole country.
Is one for Union.
He represents the Union of India.
Yes, sir.
In the Supreme Court. He is under Article 176. Article 76.
Yes, sir.
Suppose, suppose this is your institution, Rajasthali. Directors of, they have invited Chief Justice of India. They have invited the governor also. And your director is also there. In what hierarchy you will keep the chairs? The governor of state is also your guest. The Chief Justice of India is also your guest. And your director is also there. In what manner, in what hierarchy you will keep the chairs?
Sir, the governor of state belongs.
Protocol है.
अच्छा है, क्वेश्चन बहुत अच्छा है.
Sir, the governor of state also belongs to the executive organ, and Honorable Chief Justice of India belongs to.
No, that I know.
Yes, sir, but
I am asking
about the protocol.
प्रोटोकॉल
One,
क्या
two,
सीक्वेंस होनी चाहिए प्रोटोकॉल की
First chair
सीक्वेंस
would be.
sir, I would not let the
Okay,
government.
okay. I am the first chair because the president of India, the governor represents the president of India. So first chair of the governor. Second chair of the Chief Justice of India. And third chair he is the host.
Now, during your course, which subject you like, criminal or civil? You are interested in which subject? More
Sir, criminal.
Huh?
Criminal.
criminal. So this is all constitutional matters. So Munsif is not going to decide all these issues. Okay. Then what is a bailable offense?
Yes, sir.
What bailable offense?
Sir, a bailable offense is the one in which, sir, a bailable offense is the one in which the court can release an individual or an accused person and under section under section 436 of CRPC, and sir, it is an indefeasible right of an individual to get bail.
In which section they release?
So 436 is bailable.
एक सवाल पूछे खत्म हुआ।
436.
What is the definition? Bailable offense.
Sir, definition is under section 2 clause A of CRPC.
जनरल
2 clause A of
CRPC, sir.
CRPC. Now later on you will have to across a new law. So this is old law.
Yes, sir.
What is the warrant case?
Sir,
Old warrant. How warrant case? What is the warrant case?
sir, under old.
Old. We are talking only old. Now you have to read new also when you become officer.
Sir, a warrant case is defined under section 2, clause X of CRPC, and sir, a warrant case is a one in which the sentence or punishment is for death, imprisonment for life, or an imprisonment exceeding 2 years. So that is a warrant case.
Okay. How many cases? You have no question arose to decide any case. Okay, you can ask any question. Sir, आप पूछिए.
जी Ninisha, you told us deceitful intercourse. It was not prescribed in the earlier act in IPC.
Sir, it was not specifically prescribed that deceitful means or sexual intercourse with deceitful means would penalize a person. Sir, it was under certain judgments of Supreme Court. For example, sir, Deepak Gulati versus State of Haryana, so in which it was held that the the intention to deceive must be from the beginning. If a person has no deceitful means with no intention to deceive a person and indulge
जैसे कई बार अखबारों में आपने पहले भी पढ़ा होगा और अभी पुराना ही लॉ पढ़ा है,
yes sir,
उसमें आपने पढ़ा था कि एक व्यक्ति ये प्रॉमिस करता है कि मैं तुमसे शादी कर लूंगा, उससे संबंध बनाता है,
yes sir,
तो इज इट नॉट डिसीटफुल इंटरकोर्स?
sir, it is deceitful
तो ये
intercourse.
पहले नहीं था?
Sir, it was not specifically enumerated under old law, but now sir, it has been specifically included in the new law, sir. Sir, it can be traced under section 90 of IPC under misconception of fact. And sir, if deceitful cohabitation was also included under section 493 of IPC.
नहीं, उससे पहले इतने सारे मुकदमे जो चल रहे हैं डिसीटफुल इंटरकोर्स के ही चल रहे हैं, मैक्सिमम मुकदमे चल रहे हैं जितने मेरे केस है।
Sir, about
कंसेंट के बियॉन्ड थे ना?
yes sir.
तो ये पहले नहीं था क्या? पहले मान लो पहले या तो ऐसे किसी ने किया हुआ है, तो बहुत सारे केसेस हैं, आगे भी मिलेंगे आपको।
Sir, cases that are there, but those are judicial precedents. There was no specific law that a person who will indulge in sexual intercourse with a woman, but specifically by deceitful means.
आप पढ़िएगा आप एक बार इसको, ठीक है ना? अच्छा, ये बेसिक स्ट्रक्चर थ्योरी क्या है कॉन्स्टिट्यूशन में?
So basic structure was propounded in Keshavananda Bharati versus State of Kerala. There is no specific mention in the Constitution of India with respect to the basic structure. Sir, it means, but precisely it means that there are certain elements or aspects of the Constitution of India which cannot be amended or abrogated by any constitutional amendment by the Parliament, sir.
पार्लियामेंट की पावर्स खत्म है, इस पे बेसिक स्ट्रक्चर मान लो गवर्नमेंट चाहती है कि हमें हिंदू राष्ट्र घोषित करना है, वो कैसे करेगी? तो सेकुलरिज्म बेसिक स्ट्रक्चर घोषित किया हुआ है,
Yes sir.
तो नहीं हो पाएगा।
No, sir. Basic structure, sir, Parliament cannot amend or amend the basic structure of the Constitution. It was specifically handing Keshwananda Bharti. Certain changes, sir, can be made. Sir, even amendments can be made in fundamental rights. So there are certain aspects which they cannot amend in the basic
ये
structure.
9th शेड्यूल के बारे में जानकारी है आपको?
Sir, I have a little bit knowledge of.
अच्छा छोड़ दे, एक चीज पूछ रहा हूँ, आजकल बहुत सारे बाबा हैं, ठीक है, वो पर्चियां निकाल रहे हैं, बताते हैं कि आपका नाम ये है, ये भाग्य है आपका, ठीक है, और ये भी लिख देते हैं कि आपके साथ ये होगा। आर दे डूइंग चीटिंग? इज इट कवर्ड इन अंडर द penal law?
Sir, if there is any, sir, if there is any delivery of the property, or there is a person has been dishonestly in person.
प्रॉपर्टी डिलीवर करना जरूरी नहीं चीटिंग की डेफिनेशन में मान
Yes,
लो
sir.
सपोज आई एम गिविंग ए प्रॉब्लम सपोज मैं किसी सुनार की दुकान पे जाता हूँ और वो मुझे नकली हीरे निकाल के दिखा देता है तो चीटिंग हैज बीन कंप्लीटेड नो नीड टू
Yes, sir. Sir,
ये तो
but
इलस्ट्रेशन दिया हुआ है
yes, sir.
आईपीसी में
Sir, but there must be some, sir, in order to constitute a cheating, some mere dishonest mere intentional inducement is not sufficient. Sir, a person must be induced to do something. There must be an act or omission on behalf of a person who is a victim, or there must be a delivery of the property. Sir,
एक बार पढ़ना है इसको ठीक है सर
ठीक है
thank you, sir.
All right.
चेयरमैन साहब को कुछ सजेशन सर